This conference will now be recorded.
Okay, we are live streaming now. You can resume the meeting. Thank you.
Thank you very much, Benton. Ms. Marshall, Chief Enforcement Attorney, will now present the proposed citations to the board. Rebecca?
President Montgomery, members of the board, thank you. We have 8 proposed notices of opportunity for hearing for your consideration today. The first is to be issued to a DO. This is a full license applicant with a history of having his prior medical training license revoked by the board related to impairment. There's also a credentials issue because he has not practiced since 2016. The second notice of opportunity is a summary suspension. It's to be issued to a respiratory care professional. It is based on a failure to appear for a board-ordered evaluation that was scheduled for May 18th. Our third citation is to be issued to an MD. This is based on a plea of guilty for interstate travel in aid of racketeering. This physician's Ohio license is lapsed, but given the nature of the offense, which is related to illegal distribution, we did want to bring it before you. I also wanted to explain to you this is not an immediate suspension because of 2 issues. First is that the plea itself is just to the interstate racketeering and not to the actual underlying illegal distribution, and also because of his license status being lapsed. Citation number 4 is to be issued to a DO. It's based on action by the New York Medical Board. There is no information in the New York order about the specifics of this. It does appear to be similar to what we call a B34 consent agreement, where a physician agrees to be suspended pending some type of investigation being ongoing. Citation number 5 is to be issued to an MD. It's based on action by the Missouri Medical Board related to possible mental health concerns.
I have a question about this one.
Yes, Dr. Feibel.
So I assume that this was not a summary suspension based on the fact that one is going to say that this person is in Missouri practicing and therefore is not an immediate threat to patients in Ohio. I know that's been adjudicated in the past. Now that we are using telehealth as much as is being used, and the fact that there are firms, Teladoc and other firms, that are employing physicians for the purpose of telehealth, it certainly brings into question what an immediate threat to practice in Ohio is, because somebody could easily be in Missouri and get on a telehealth service to take care of patients in Ohio. So I think it's something we as a board need to address. And then the second thing about that is we're currently doing Strauss legislation, and in that legislation, I would, and we can talk about this in the policy committee, but I would like to see that if somebody has voluntarily resigned their license in lieu of investigation or while an investigation is going on, it must be something egregious in that state, and therefore it would be nice if statutorily we could, similar to the way we use for medication prescribing, people pleading guilty to medication prescribing, it would be nice to automatically be able to take their license until a hearing. I don't know if anyone has issues.
Thank you, Dr. Feibel. I think your comment about telehealth is a really vital one for us to consider working with our enforcement attorneys going forward as we discuss this. This is a very important question to be asked and considered. Dr. Schottenstein.
Thank you. I'm hoping that, when we do reference the statute, which talks about imminent risk of harm, that is something that is inherently considered by staff, which is the fact that telemedicine exists and that that's a possibility. Because, if there's a judgment that staff makes that telemedicine is something that this doctor either, has a decent probability of pursuing or will pursue, I think we're right to incorporate that into our decision tree in terms of whether or not we do decide to summarily suspend. It just should be, I think, an automatic consideration of staff and secretary and supervising member as they contemplate whether or not to summarily suspend. The only other thing I would say in terms of Dr. Bible's comments, which I appreciated very much, is I'm always a little bit tentative about automatically taking somebody's license. It is depriving someone of livelihood, and we don't often have much detail about what goes on in other states. And so I just want to be careful that we're not, going to abruptly, take away somebody's livelihood when there may be, extenuating circumstances. Some people may not want to, bother with the bureaucracy of maintaining the license in a state if they were, let's say, planning on, moving or giving up their license there anyway. And, I want to be careful about that. Thanks.
Any other comments or concerns? I think it's a really important point you've made, Dr. Feibel, Dr. Schottenstein, and hopefully both are, as we go forward talking about telehealth, we'll absorb that all, both within the board membership as well as with regard to staff. So you want to proceed, Rebecca?
Yes, thank you. The sixth citation is a summary suspension. It's to be issued to a massage therapist. It is based on a failure to go to a board-ordered evaluation for possible impairment that had been scheduled for May 24th. Citation number 7 is to be issued to an MD. This physician is currently suspended. Bifurcated step 1 consent agreement from November. That consent agreement was bifurcated so that the separate investigation on different matters could go forward. This site is based on that. It is for sexual misconduct involving 3 patients, acts constituting deception to obtain, as well as non-consensual dissemination of sexual images. Our last citation is to be issued to an MD. This is based on multiple federal convictions that just occurred a few days ago on June 4th for sex trafficking of a minor and production of child pornography. The board was well ahead of this. This physician has been suspended since December of 2019 under a consent agreement related to that indictment. Thank you very much.
Hey, Rebecca, thank you so much. I have a question here.
Yes.
Can the enforcement folks working with Stephanie Luca and company figure out a way in which we're processing? So often we don't know that there is an indictment out somewhere, but there are major stories in other parts of the state. And is there anything we're doing now to monitor, or any proposals that you are looking at so that we can be in a more timely way be engaged? He was indicted prior to 12/11. And we're coming, and thank you. It's only a couple of days since he was found guilty that we worked. You can ask for a more timely response by the board, except that we could have perhaps 6 months earlier acted, and if we had processes in place. So are you working on that, or how do you do you have any proposals on that?
Yes, so I'm a bit confused. On this particular case, the original indictment was in September of 2019, so it was about 11 weeks later when we were able to get that negotiated agreement before the board for ratification. So that was also extremely fast. As far as your general process question, I know there are people in the agency that watch the newspapers. We have the investigators throughout the state that are well connected with different task force and law enforcement. So we generally know if an indictment is coming or if an indictment has occurred. I think our challenge, as we've discussed a number of times, is when you only have an indictment and you don't yet have a conviction, there isn't a lot of teeth for the board to always be able to take action. So we always try to do those agreements when we can, and to work with law enforcement and to do whatever is possible. Sometimes we are at the mercy of the court system.
Mm-hmm. Stephanie, do you want to thank you very much, Ms. Marshall. Stephanie, do you want to comment on that a little bit, just so the public is aware of what we're doing to try to move as quickly as we can in these kind of cases where there's an indictment.
Absolutely. So we are actually working on legislation right now that would allow us to take action on these scenarios in an indictment, with an indictment. And we have seen it time and again. It's something our enforcement attorneys, and I'm sure the secretary and supervising member would like, and we've seen that numerous times. So we are working on that legislation. We hope to be successful with that. We do know that we will probably meet some resistance because, again, there is that concern that that is not a conviction. However, the fact patterns that we see are so egregious that they lend themselves to us moving forward on that suspension, or on taking action upon the indictment. So we are working on that, and we are monitoring the news on a daily basis. Our communications team is giving us daily clips, and so we are watching for these stories when we are not alerted by the courts as well.
Well, thank you, because of course we're trying to figure out how to get that notification happening routinely, and it's already in statute in terms of some requirement, but that doesn't. It's not always followed. Mm-hmm. So, are there any other? If that's the case, Ms. Marshall, do I hear? Any other comments or concerns? If not, then do I hear a motion to approve and issue a citation number 2 on citation number 2 on the summary suspension? Is there a motion? Motion by Dr. Feibel. Is there a second?
Second.
Dr. Soin. It's been moved and seconded. We have a roll call vote. Dr. Rothermel? I'm sorry, can't hear you if you answered.
Abstain.
Okay, Dr. Safran?
Abstain.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy? I'm sorry, was there a response, Dr. Reddy? Moving on, Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Dr. Feibel?
Yes.
Montgomery? Yeah.
I'm sorry, this is Ben. Dr. Reddy, could I confirm your vote on that?
Yes.
Thank you. I
Thank you
didn't
very
catch
much.
that before. Appreciate that.
Thank you very much, Benton. Do I hear a motion to approve and issue citation number 6, a summary suspension? Is there a motion? Motion by Dr. Feibel, second. Second by Dr. Johnson. A roll call. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Reddy.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Dr. Feibel.
Yes.
And me, Betty Montgomery, yes. So would any board member like to consider any other citations separately? If not, hearing nothing, do I have a motion to approve and issue citations 1, 3 through 5, and 7 to 8? I have a motion?
So moved.
Dr. Johnson.
Okay, Dr. Johnson's moved. Is there a second? Dr. Soin?
Yes.
Okay. Roll call. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Dr. Soin. Dr. Soin, I'm sorry, I didn't hear you. Yes?
Yes.
Okay. Dr. Schottenstein.
Yes.
Dr. Reddy.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Dr. Feibel.
Yes.
And me, Betty Montgomery, yes. Okay.
Ms. Montgomery, if I can interrupt for just a moment, the board does need to go back to the settlement agreements to vote on those.
Okie doke. Well,
If you
I
back
hear-
up the page. Thank
do
you.
I have to go back and I'll go back to and go through all of them again then. It'll be very quick, I promise.
Yes.
Do I hear a motion to ratify the proposed permanent surrender of PMH MD?
So moved, Dr. Coccarella.
Is there a second?
Second.
All right, Dr. Rothermo,
Abstain.
Dr.
Dr. Safran,
Abstain.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Dr. Feibel,
Yes.
and myself, Betty Montgomery, yes. Referring to NVR, the DO settlement agreement, do I hear a motion to ratify the proposed permanent surrender retirement of NVR? Is there a motion?
So moved, Dr. Caprella.
Seconded by Michael Schottenstein. Dr. Schottenstein, roll call, Dr. Rothermo,
Abstain.
Dr. Safran,
Abstain.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Coccarella,
Yes.
Dr. Feibel,
Yes.
and Betty Montgomery, yes.
And me.
Dr. Johnson.
Dr.
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 Johnson.
Johnson, I'm sorry. All right, so then we're moving on to VJM. Do I hear a motion to ratify the proposed consent agreement with VJM DO?
So moved, Dr. Caprella.
Dr.
Second.
Coccarella, second by Dr. Johnson. Roll call vote, Dr. Rothermo,
Abstain.
Dr. Safran,
Abstain.
Dr. Swain,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Dr. Feibel,
No.
and Betty Montgomery, yes. Moving on to MMP MD. Do I hear a motion to ratify the proposed permanent surrender of MMP Dr. MD? Is there a motion?
So moved, Dr. Caprella.
Dr. Coccarella, is there a second? Dr. Johnson?
Dr. Johnson.
Roll call, Dr. Rothermo,
Abstain.
Dr. Safran,
Abstain.
Dr. Swan,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Dr. Feibel,
Yes.
and me, Betty Montgomery, yes. I think I've completed that now. We can move on, Mr. Parliamentarian, to the operations report. Any issue with that? We'll move on to the Executive Director, Miss Luca, for the operations report.
Thank you, Ms. Montgomery. So for my operations report today, we have continued to stay exceedingly busy. We are in the midst of hiring a few positions right now. We have our central area investigator supervisor position has been filled by Jeff Bradford. I think Jeff is familiar probably to most of you. He's been an investigator with us for a long time, and it's certainly wonderful that we have him now in that supervisor role with Sean McCafferty as the chief of investigations. We have also are in the process of filling 2 licensing positions. We had a new employee start this week, and we've been doing some training and licensing with her. So it's been great seeing some licensure staff faces around the office this week for that training. With respect to budget, I'll skip that for the sake of times. Dr. Schottenstein will go over that in his financial report with all of you. I would just note that we are still continuing to see those delayed renewals on licensure that were a result of House Bill 404. Folks have until July 1st to renew. And so we have, hundreds of thousands of licensees around the state, and in particular with us, a little under, I believe it's 8,000 who have not reviewed. Keep in mind that a normal renewal cycle, we do not have between 4,000 and 5,000 folks renew. So we are probably about 3,000 behind right now, approximately. All very approximate. With respect to legislation, Chelsea will be giving a full legislative report out in the policy portion of the meeting. However, we've been very busy talking with legislators and other decision makers as the budget has been moving through the process. It came out of Senate Finance yesterday and will head to conference committee soon. So we're looking at those amendments carefully. We got those last night. Again, Chelsea will report out, but as of now, our appropriations are all okay. They're as we requested or as they came out in the executive version of the budget. So we've now made it through 3 cycles of our appropriations looking good for next year. So we'll include some new hires with those appropriations. And I will not bore you by reading through statistics with you. For those of you who like the data is there. For those of you who don't, just a summary to say that our numbers remain higher than ever, and with respect to what's coming in the door. So the good news is that we are, and this is not reflected in a data set in the operations report, but over the past few months, we have been closing, citing, or settling cases, either through enforcement or investigations or standards, at a pace with which they're coming in. So we are not contributing to further delay with cases with respect to us, the investigations and enforcement standpoint. We do have a considerable backlog in our hearing unit, and we plan to really look at our options there with both contracting and full-time staffing added to the hearing unit, so that we can clear through some of those hearings. We only have so much bandwidth. The AGs can only do so many big cases, and the hearing unit can only do so many big cases. So short of adding bodies, it is what it is. I think we've tried to optimize as much as we can, and had some good conversations about trying to be as optimal as possible. It just, again, kind of is what it is with respect to where we are. We have a couple, I think I've mentioned previously, we have a couple special projects that we're working on. And one that I alluded to earlier in the FSMB committee, and that's really creating some standardized Salesforce training for all of our staff and for those board members who use Salesforce. And so being able to offer job aids, video training, I think the end result of that will be some real efficiencies in the way our data is being created, in the expectation of the way the data is stored. So, for example, what's in an ROI, right? So if you're following your job aid and looking at your training, we're having some consistency of what's also going into Salesforce. I do think that will create some efficiencies for us in the way we are processing our work. Licensure has been extremely busy this year. They've been down a staff member, and training certificates are at an all-time high, which is great for our new Ohio licensees. But it is the volume has been extraordinary this year, and they're doing a great job. They've volunteered to do some overtime work, so we are grateful for their overtime work. And as you can see, their emails and calls continue at a pretty high rate. Again, I kind of spoke to the complaints piece of thing. We're keeping pace with complaints. And so we are continuing to work on strategies that help us get to some of what is I would say, it's kind of like that iceberg. What we're seeing at the top is what's coming in the door and what's going out the door, but really that iceberg of complaints, and how can what tools do we need in the toolbox, and how can we do sort of a strategy to see how we can move these along, particularly those in enforcement. So with
Stephanie, I'm going to stop you there with regard to that. You are moving towards some proposals to attack the backlog.
We are.
Okay. And when do you think you might have a proposal to the board?
So it will be shortly after we return in person. I would like to say July, but I know that we want to have some discussion with the secretary and supervising member, and really it lends itself to some brainstorming. And I think we're better off doing that in person. We've all sort of talked about that being a better discussion in person, as staff with the secretary and supervising member. So we'd like to do that before we do that with the board. So depending on how those conversations go later in June, early July, it could be July. I would actually project August.
And also, with regard to that, will we be having a retreat this year?
Yes, we will. Assuming that you all would like to. And I think we need to talk about what the timing of that looks like and best date. So, I think as new president and vice president, maybe the three of us can talk about next steps with that, and then send an email out to the board very soon. I know schedules fill up quickly, and so we want to make sure we're moving on that sooner rather than later, getting a date on the calendar.
Okay.
Thanks. And just a couple of other things to point out. I would like to give a thank you to the communications department for all of the work they did on the duty to report video. It has been released. I will say that first, starting with the positive, we've had overwhelmingly positive feedback about the video itself from the physician community. The content of the video, thank yous from people. Thank you for reminders. Of course, we've had some negative, you shouldn't be making me do CMEs. We had one comment that actually said that we were bringing to light problems that the public, we were eroding trust because we were making the public aware of problems that exist. We said, thank you. Yes, that's our goal. We've had some really positive feedback. Technically, it's not where we want it. We are working with a few folks to get it to a more optimal viewing platform, especially with a certificate that's printable from the video itself. And so we're working on that, and we hope they have traction on that within the next few weeks. Just a little more polished on the platform delivery. We have what we have. I don't want to make excuses, but we are doing this. We're not a learning management center. This is a sort of a side project for us. So I think it turned out really well. The filming was great, and especially in a pandemic. And we'll continue to evolve the content. We have received questions from stakeholders. A variety of questions, and we're willing to work with stakeholders as they review this. We had one employer say, we would like to all sit down and watch this together. May we all do one screening and work with you on some sort of certification after that one screening with multiple doctors. I think that's a great idea. I think it lends itself to dialogue. And so we're working with those individual scenarios. So we encourage people to reach out to us and make sure that we have the security, that we know that folks are watching it, but also that it's user friendly. So we're happy to deliver that. Some groups have asked to actually host it on their own servers, and just so have the video file themselves to be able to host. So we're happy to do that as well. So we've had some good feedback on this, and people are talking about it, which is what we want. Yes, Dr. Feibel.
I'd like to say a great job on this. I think it's a really important thing. It is a new thing for licensing that we can do to try to get communication out like we're doing through the associations and other places, that this is a new requirement. Anything we can do on the web as they're renewing to make sure that they understand that they click through things and say, yeah, I've got it. Would be great, because that's super important. Gotta love dogs at home. We won't have that next month, I promise. I won't put my dog in.
Thank you, Dr. Feibel. Point well made. We are, as you said, we are working with the associations. We're putting it on our website. I don't think there is a way that we can over communicate this. I mean, we have to be talking about this constantly with people. And certainly our position is that we don't want to be in a game of gotcha with this. Right? Our end goal is that we want people educated about this and have folks looking at this and doing the right thing with this, or asking questions of us, erring on the side of reporting to us. Let us make the decision on whether or not it should go forward. But this should not be something like, oh, we put a video out there and now we get to do all this enforcement because you knew and you didn't watch your video. That cannot be our goal here. We need people to understand what the goal of the CME is truly education.
Stephanie, have we have ongoing discussions about some potential interim discipline degrees of discipline other than what we already have in the books and the rules?
Yes, so that will be part of those conversations we have with secretary and supervising member that we bring back to you for full discussion in likely August.
And that would include something like perhaps the warning letter or the something short of the formal stuff that we've just, for example, done today.
That's right.
Okay.
Absolutely. Dr. Schottenstein, did you have a question?
Thanks kindly. I just had a couple thoughts. One is that I thought having an actual victim speak in the video was really moving and impactful. And I think that's something that we'd be right to continue to implement. I thought Dr. Johnson did a great job on the video, so I really appreciated that. I thought Dr. Levine, I thought Dr. Levine was great also. He was really well-spoken in terms of his explanations. And I guess I also would just mention that, the duty to report, I guess it maybe bears reminding us all that it's not just our physician licensees that have the duty to report. All of our licensees have the duty to report. It's just our physician licensees that have the CME requirement though, right? So everybody has to be mindful about this important rule.
That is correct. That is absolutely correct. We are branding our educational materials to all licensees, having those conversations with associations. So we sort of have a mini communications campaign to all licensees about that duty to report. This CME is relative to those professions who have the required continuing education. That's right. Okay, and then my final update for you is I would just like to thank one of our staff members, Michelle Richards. She is one of our investigators who has been serving in the victim advocate role for the past year, victim coordinator / victim advocate. And I'm happy to announce that she has now received credentialing as an advocate through the National Organization for Victim Assistance through their National Advocate Credentialing Program. It was a lot of training and testing and sessions that she did completely on her own and took the initiative to do that. And so we're really grateful. And it's a great addition for our staff, one of our staff members to be able to have this. And I think it's a testament to, just the culture of having the victim coordinator working with us all in our different units as well, that this role is really embedded in the work that we're doing. So we're happy to have that.
Congratulations. Thank you very much, Ms. Luca. Anything else from the board? Any other questions? If not, we will move on to rules and policies. Ms. Anderson?
Great. Thank you very much, Ms. Montgomery. So first we have the rule review update, which just gives you an idea of where the various rules are with us. I will note that since filing with you, there's been a little bit of movement for rules at CSI. The consult rules for physician assistants have been released from CSI. I have not yet filed those with JCAR, but they are ready to do that. We also, on the other column, we have a rules hearing scheduled for June 28th, so coming up in a few weeks, on the ORS rule, the pronouncement of death rule, the delegation rules, and sexual misconduct rules. So that will happen on June 28th. I would note, so we'll talk more today about the light-based rules. Those were placed in TBR status to give you an opportunity to hear the comments that we've received. And then we have two other sets of rules in that package, the dietetics rules and the hearing rules. I would just bring to your attention, Dr. Schottenstein, in one of the dietetics rules, 4759-602, found a typo. I would like to correct that typo with JCAR, and then when I bring it back to you for the final adoption, you'll have that. Just a word was crossed out that shouldn't have been. So I'll double check that and make that correction, but I just wanted to let you know I was going to do that. Other than that, I don't have anything unless you have questions about just the general rulemaking processes.
Are you going to get specific on the cosmetic therapist? Is that another?
On the light-based, yes, I will. So if there's no other questions, I'd like to move on to the podiatric scope of practice issue. So you have materials that are provided. After our meeting in May, I sent a letter to the chair of JCAR advising him that the board had voted to pursue the rulemaking process. And then I was notified by JCAR that I did not need to attend the June 7th JCAR meeting, which happened 2 days ago. I did watch it, and the chair did notify the committee that the board had agreed to go through the rulemaking process. So they don't need anything further from us on the policy to rule issue. Also, in the materials that you have, I have drafted a notice to the public requesting public comments on this podiatric scope of practice issue. There's a cover memo, and there's the response to Dr. Logan from June of 2019, and then there are the two podiatric rules. And so we're seeking comments from the public that the board should consider as it starts in the rulemaking process. I would like to, or I will plan to put that out to the public. We would like to send that to our physician and podiatric licensees and put it on the website, and also send it to all our interested parties who have requested information in the rulemaking process. So I will plan to do that. My goal is to give the deadline of July 2nd for the comments, and then we will be coming back to you with them. Depending on the volume, it will, I think, depend on whether we're bringing them to you in July or August. I think we may plan for August, but we'll have to review what we get. So that is, I think, just an informational point. If there are any questions or comments.
Only one. This is a legitimate. There are been some legitimate differences expressed on the board, and so gathering this information is really important. The problem is, of course, it's very time consuming, and at the same time, these scope of practice issues tend to be settled not by the medical board, but by the legislature. And I don't know if there's going to be any legislative action, but if there were legislative action, at that point, I am assuming that the board would then step back and do its due diligence in a hearing process over in the General Assembly versus continuing to do our own due diligence, or to continue to do the work that you've just discussed that we were doing. Is that a correct assumption?
I think if there is legislation, I think we will want to make sure that we're communicating with the JCAR members about this. If circumstances are changing and we're going in a different direction, or we're delaying to see what happens with legislation, I think we would just need to make sure that we're communicating that with the JCAR members. At this point, I'm not aware of any legislation, and I think we would plan to, move through the rulemaking process. But I think that's a very good point. If there is legislative action that would impact those rules, we would need to have that discussion.
Yes, and I only bring this up because if the interested parties, if they're going to go to the legislature, it's, I hate to see our board and our staff spend the exhaustive amount of time that they're going to be taking on this issue when we will be essentially only testifying either as an interested party or pro or con any legislation. So if the legislation is going to be introduced, in my way of thinking, it seems to me sooner rather than later, just for purposes of this board being able to be relevant in its expression of what its concerns are with any proposed legislation, but also not spin our wheels for something that's not going to result in anything that's relevant because we'll be precluded by legislative action. So it's just an observation, and we'll see what happens with the interested parties and whether they're going to go to the General Assembly and bypass us, essentially. So,
Right.
which usually is what happens. So, all right, moving on to the light-based medical devices then.
Okay, thank you. So, so we had the public rules hearing on May 17th for the light-based medical device rules. And as you can see, we received a number of comments, quite a few. So given the timing, the JCAR meeting was scheduled for Monday. We wanted to give the board an opportunity to review these comments before the JCAR meeting. And so the rules were placed in the TBR status, to be refiled status, which is sort of like tabling them. And but because we have this emergency rule out there that's going to expire on August 8th, I really need to have all of the amendments that you would want to make really filed by tomorrow, so that we can be on the schedule for the June 28th JCAR meeting, and then have a rule adopted at the July meeting, so it's effective before the expiration of the emergency rule. So to help you with that, what I've done is kind of gone through each of the comments. And so the memo is lengthy, but I have kind of categorized the comments and then given you my recommendation. So I'll just start, and then if people want to jump in, feel free to do that. I think the first comment is that physician assistants should be able to provide more types of laser treatment. I think the overall issue is they are, with this rule package, getting to do additional types of laser treatment, the non-ablative vascular lasers, which they cannot currently do, is being added to something that can be delegated to physician assistants. We did receive a comment from Scott Kackler, who's the chair of the PAPC. I don't think this was, so when we talked with the PAPC, it's not coming from the PAPC itself. I think it really is from Scott Kackler, but he is recommending removing the words authorizing the service so that there's not a confusion about what needs to be in the supervisory agreement. And I would recommend to you that you could make that change, and that is in 1803 and 1804 in two different places in each rule, just deleting those words authorizing the service. I think his concern is it sort of makes it look like it's a specialized service plan that like we used to have for PAs. And so I think that if that helps with confusion, that would be a good recommendation to take. The other comments are really things that the board has already addressed about not having the physician do the initial review and the review after the initial application of the laser. And the board fully addressed that in the March meeting, that was still necessary, but could be done via telemedicine. So in the rule that was filed did make those changes that the board had requested. Then going back, the next group of comments were from the cosmetic therapists related to the training, education, and supervision requirements. And there were also some comments seeking to expand the use of light-based medical devices beyond laser hair removal for cosmetic therapists. I would not recommend that you do that. They're citing meeting minutes from Dr. Bechtel. I think that was just an error. I don't think there's any indication that cosmetic therapists have the training and education to do other types of laser treatment besides laser hair removal. So I'm not recommending that. But I think we did want to talk a bit about the training and education requirements. And there are a couple of places where I've noted with respect to the comment from Marley Miller and with the comment from Marty Sweaterlich, that it would be good to have some board discussion on the proposal about whether the training and education that's required for the delegation, if some of that could happen in the initial training that cosmetic therapists do. So I would open that up to board discussion.
Kim, I'm sorry, Dr. Schottenstein, get to you in one moment. We've had some, as we know, it's taken, I think, 5 years to develop these proposed rules, if I'm correct.
It has been a process that has been 5 years. It's gone through, it went through an antitrust review, which added quite a bit of time. Yes.
Mm-hmm. So we've come down to a question about, continuous availability of a doctor who has done the delegation, and whether or not it requires to be within the 60 minutes, or how we propose to address that. And I think you're proposed to say that the doctor should be continuously available, so that it doesn't, and telemedicine works in that regard.
You can do that if the board wants to. So you don't have that in front of you, but if you want to delete, so an issue about 60 minutes travel time for offsite supervision for cosmetic therapists was raised, and that is coming. So one, that is not any different than what currently exists. It's currently in 4731-1803E, but in 4731-1801I, capital I, the definition of offsite supervision includes that the physician is not located more than 60 minutes travel time. And it also, at the beginning of that definition, says that the supervising physician shall be continuously available for direct communication with the cosmetic therapist and must be in a location that under normal circumstances is not more than 60 minutes travel time away. I think we could propose deleting that second part of the definition and just leaving the first part, that the supervising physician shall be continuously available for direct communication.
Okay, so that's one issue. The second is, and then we'll get to Dr. Schottenstein, is in the education, talking about, I know the concerns in education have been, are we asking doctors to be trainers, and whether they would do it in an appropriate way, or whether this essentially would mean that the doctors would not be doing it, and that this very small group of basically independent, generally women, 200 of them, would be without ways to make a living as a cosmetic therapist, or be very limited. So our discussion there has been, let the career colleges and schools and the board working on the curriculum to make sure that the curriculum that the students make sure that the students are properly educated pursuant to what our what the rules are requesting that they have to have proficiency on. that then there's a certification by these schools or programs that this particular student has met those qualifications. And then the doctor would be required, if they want to do a delegation, to ensure that to whom they delegate have met that certification, to check to make sure that the certifications and the continuing education occurs. And then finally, so we have the attestation occurring through a school, all the other things require. If the doctor doesn't do it, then they become liable if there's a problem, if they delegate to somebody who's not properly trained. So we address the continuously available, understanding what telemedicine has taught us. We talk about certification, the proper training that's required, and what the schools or programs need to attest to with regard to their students. And then we talk about what the doctor's responsibilities are in delegation in this proposal that you are going to make to address the concerns that have been expressed over these many, many months and many, many minutes of conversation that you've had and I've had and many have had. So, Dr. Schottenstein, I would defer to your questions.
Well, thanks very much. I guess I would substantially echo that. I think that it's a legitimate point for the licensee to say, as Ms. Miller did, why do I have to duplicate the education that I've already received by having to do additional procedures under observation and such as per the rule. In other words, if there can be overlap, if the licensees can have their didactics and have their their requirement of procedures of observation and training while they're in the school setting, then I think it is entirely reasonable that there be the ability to have an attestation that has been done. I think that if in the course of a licensee's education, the criteria of our rule have not been met, then I do think they should, subsequently engage in education and training to fulfill the requirements of the rule. I just don't see that they have a need to duplicate it, and I think an attestation would address that for them. I think that's fair. And I also think, if I may, that we're right to delete the requirement of the 60-minute travel time. There were licensees who wrote in and said, the physician goes away for a couple of weeks on vacation and he's more than an hour away. Our office has to shut down. And so when we have the capability of telemedicine, I just don't think that's necessary. I think it's legitimate in the same way that we said before that telemedicine has a place in physician assessments in these cases, that it also be able to be utilized to allow for that continuous involvement and obviate the need for the 60 minutes of travel time. Thanks.
Thank you, Dr. Schottenstein. And then one other thing that we have to address is what happens with our students who are currently being educated. And if you could, Ms. Anderson, talk about exemptions and that, so that we're addressing any as these changes are occurring.
Okay, sure. So in 4731-1803, so just kind of going backwards a little bit, what we were trying to do with these rules is put in some detail about what is the training and education that is required for people to be able to apply the light-based medical devices. And so that's where, kind of this comprehensive didactic training and then observing and then doing observed procedures came from the group of dermatologists that we worked with in developing these rules. And then the cosmetic therapists, I think, did bring up a point about, their education and training requirements. I think we can have an amendment that would say if The program can provide us with written verification to the physician that their training met all or part of those requirements. Then they wouldn't have to redo that. I would also say that we recognize that there were people already doing laser hair removal that haven't gone through all of these, observed procedures, and they've been doing it for years and there haven't been any issues. So there is in the rule kind of a grandfather provision for individuals who have been doing this for 2 years, that they're not subject to those additional requirements. For people who have not been doing the laser hair removal for 2 years or who are just coming out of school, then if we add this little paragraph F, they would be able to, so we would be adding it to 4731-1803B7 little f, which would allow the physicians to obtain written verification from the program that they've done those observed procedures and they've done the didactic training through their educational program. So I think it addresses that, not completely, but it.
Being able to look at something via telehealth, or would there be a reason that a physician would actually have to come if something happened that to help with the situation? So is there a physical presence needed, and do we know that? Because then
it was a really old provision. These rules were first developed in I think early 2000s, and I think it mirrors some language that we used to have around PAs, requiring the supervising physician to be within a certain location. And I think it just kind of predates telemedicine. So I think that's where it came from. We hadn't made a change to it. We just moved it to a different place.
I guess what I'm asking, are there negative things that can happen during these procedures that would require a physician to actually come on site to do something? And does anyone know that?
I don't know that information. I know that there does need to be, direct oversight. This particular definition only applies to the off-site supervision of physicians with respect to cosmetic therapists. If there are other licensees doing this, PAs, it's going to be under their supervision agreement with the physician. And for RNs and LPNs, off-site is not an option in the rule.
I guess, is there a way to verify, maybe from even like Dr. Bechtel, who I'm happy to reach out to, just to make sure that there's no reason that somebody would have to be physically present if something happens that could be dealt with over telemedicine? Because I don't think.
I really need a decision on this today.
Okay.
Yeah, I mean, in theory, you can potentially, if you have somebody, using a device, in theory, I suppose you could worry about some kind of, thermal injury or something like that. But in a practical sense, those patients are going to get sent to an emergency department. It's extraordinarily rare when we talk about what kind of devices that fit this criteria. These are like medical lasers that we use in the OR for, like, when we try to do tumor reduction or ablation of tumors, like in the airway. This is a far lower grade. You would have to almost have it directly applied and continually applied for a long duration. It would have to be like the patient fell asleep, the person running the machine fell asleep, and it was for not just minutes, but like an hour or two. And they were almost unconscious, so they couldn't move away from the device. So
Thank you, Dr. Coccarella. Dr. Rothermel, did you have a question, comment?
My comment was exactly what Dr. Coccarella made as far as the emergency department. And it seems to me that somebody that's evaluating even over telemedicine would probably recommend moving to the emergency department. So
Yeah.
probably unnecessary to have them there directly.
And that was my thought too. Yeah.
So,
Thank you.
unless there's other comments, I guess what I would say to all of you, you will recall that we have been scrambling on this because of a General Assembly action where unilaterally a decision was made to unlicense these people, and the concern of safety for the public with regard to this. And so I have to give great kudos. I think we all have to give great kudos to the amount of time spent by this staff trying to make certain that these cosmetic therapists are capable of continuing their work and continuing their work safely. So that required an emergency rule, as you recall, and that took a great deal of time. And then over the time, the staff has been working continuously with the interested parties, and much thanks to Kim and the folks and Stephanie for all the work they've done to try to accommodate the needs. We have, to get to JCAR, we have to pass this rule today so that there is not the emergency rule ends, and then there's no, it's a Wild West. Anybody can open up their license, open up a license and do the work that we're trying to regulate as best we can, given the fact that they are no longer our licensees. The discipline we have no disciplinary process, but the discipline that happens, that might happen is these cosmetic therapists could be charged criminally for the practice of medicine, illegal practice of medicine. That would require a prosecutor prosecuting that, and so the thing that we can constrain appropriately is these doctors in the delegation process by checking that these are properly trained cosmetic therapists. They take on the responsibility, and if they fail to do that, then they are open to whatever litigation might be happen if there's anything that is, as Dr. Coccarella discussed, if something happened untoward or so. That being said, and Liz, is there anything else, Kim, that we have to talk about?
Yeah, just one more thing, and then I can kind of recap the amendments if that helps people to understand.
Okay, that'd be great.
We're talking about a lot of different things. One more thing is Larry Wolpert, who is the executive director of JCAR, reached out. There was a typo in 4731-1803, just a random number was stuck in. So we'll take care of that. And then also he questioned whether we should be defining direct physical oversight by the physician when observing individuals doing the laser surgery or the laser application. And this is for the non-ablative vascular lasers and the lasers for hair removal. If the physician is doing that oversight, there is a place where the individual that is delegated is doing that under the direct physical oversight of the physician. And he questioned whether we should have a definition if that's different than on-site supervision. And I think that's probably a good point. And I would certainly be open to what board members think, but I think we could define that and add it to 4731-1801, which is our definitions rule, and just say direct physical oversight means the physical presence of the supervising physician is required in the same room to directly observe the delegate of the light-based medical device. So if that is okay, I would add that to the definitions rule.
That's great. So I guess what we're left with is, and so folks understand, Kim is scrambling yesterday afternoon late, rewriting this rule. And if there's anything else that needed to be added at the last moment, I suppose what we would have to say to the board, do you have a problem with, if we agree that this is an amendment, we want to move on to JCAR, if there's any last minute amendment, would the board give permission to Kim to talk with me? And we make any, generally they would probably be they certainly wouldn't be hugely substantive, but if there were something that came up that we could make that change without having to come back to the board and delay the rule being sent. So are we at a position now, Kim, where we should ask the board to you make a recommendation for the amendment and ask the board for a vote? Are we in that position? Or the board, have we had sufficient discussion about this? Okay, if that be the case,
I think Dr. Johnson has a question.
No,
No,
I'm sorry,
I was just going to make, Ms. Montgomery, I was just going to would like to make a motion to proceed with the amendment as Kim stated, and also that if any further changes need to be made, that she discuss that with you.
It's been moved. Is there a second?
Second.
Okay, it's been seconded by Dr. Coccarella. I think we need to take a vote on this. Do you not think? So let me start with Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Dr. Soin.
Yes.
Dr. Sattenstein.
Yes.
Dr. Reddy.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Dr. Feibel.
Yes.
And then myself, yes. So, Kim, go forth and do what you do with JCAR.
All right. Thank you.
We move on to the telemedicine. Is there anything else that, Kim, that you have to talk about in your rule discussion?
I don't. No, I think Nate Smith is going to talk to you about the telemedicine
Great.
issue. Thanks.
Nate, you're on board.
Thank you, Ms. Montgomery. Actually want to bring in Stephanie Luca as well on this. She and I, as well as Kim, have been kind of discussing sort of next steps in relation to some of the orders that were made well over a year ago related to, the board policy related to telemedicine that started in March of 2020. So I will jump in when Stephanie feels is necessary, but I think Stephanie's going to kind of introduce the topic.
Sure. Thanks, Nate. So where we are right now, we are still acting under an Ohio declared state of emergency. The governor declared a state of emergency in March of 2020, and the board subsequently, at a special meeting, took action to suspend enforcement of in-person requirements, essentially for a variety of scenarios. In other words, to let those rule-driven in-person visit requirements be done via telemedicine. And there are a host of those that are impacted, including acute and chronic pain prescribing, medical marijuana, weight loss drugs, and I might be forgetting one, but you get the picture. And so we have those visits have been done a lot of those visits have been done via telemedicine. Well, again, the board took that action dependent on the declaration of the state of emergency in Ohio and until the state of emergency ends. The board also noted that it would give licensees time to readjust to the end of the emergency. I want to be very clear, the state of emergency in Ohio has not been declared ended. The governor still has that state of emergency. We just don't know when that will end. And it could be very soon based on numbers, and that's not up to us. But I think we need to be prepared in the event that emergency ends at some point between board meetings. Further complicating this, we also know that the federal government has taken action on the federally declared state of emergency. And there are certain actions that have been taken with respect to prescribing via the Ryan Haight Act, and those are tied to the federal emergency. Nate has done some research, and we have determined legally that the federal, I guess, suspension of enforcement really sets the floor, and then a prescriber has to be in compliance with the state law. So just because the federal government has said that enforcement is suspended does not mean that the state has to suspend enforcement. In many scenarios, federal law preempts, not in this scenario. The provider has to be in compliance with both state and federal law. So I think as we may move forward, what our ask is of the board today is for discussion on what happens next with respect to our suspension of enforcement if the state of emergency ends. And with that, I think that whatever is decided next with the board, we would recommend, we've had many staff discussions about this, we would recommend a 60-day phase-in of whatever that looks like, whatever decision we make, so that we can communicate fairly with licensees, make sure that we're educating, and make sure that we're really reaching out. And obviously that timeline is also up for discussion. So the question on the table is where we go next with respect to our suspension of telemedicine enforcement.
Do you have any comments? Dr. Schottenstein.
Hi, thank you so much. Well, so Ohio may lift our suspension of our requirements unilaterally, but I think it will add an element of confusion to the process if we do it independently of the federal lifting of requirements. I think it would really require a lot of communication to our licensees, so as to minimize that confusion if we were going to do that on our own. The other thing we could do is simply time our lifting of our suspension of requirements to the federal lifting, and just do it simultaneously with them. And then the other question is, in terms of our rollout and such, and a 12-month requirement, how much time are we feeling is reasonable for licensees to fulfill the in-person requirement once we do, lift our suspension? Because, if it is immediate, then all of a sudden, all the people who have been, seen through telemedicine over the past year will need to get in right away, essentially, to fulfill, that criteria. And so I do think it makes sense to have a substantial buffer in that regard, so that offices are not overwhelmed by the lifting of the suspension of the requirement. Thanks.
I would only like to respond to that by saying, and Dr. Schottenstein and I have talked about this just briefly, and I would respectfully disagree with Dr. Schottenstein. I think it's time that when, and I will admit to certain bias, I don't believe that we have to be tied to the federal government, particularly since they have, in I guess a personal opinion, they haven't shown a great activity in solving problems in a timely fashion. So, if that's a polite way to put it. So I would much prefer that Ohio, steer its own ship, and that we move as quickly as possible to be as convenient and user-friendly, given what we've learned over the pandemic experience. So we have a polite difference of opinion, and I would invite the board to weigh in here. And anybody else have an opinion on this? You're very clever, all of you. I guess it requires us to, this might require just a motion or?
Explain to me when is Ohio, we don't know when Ohio is going to lift? And
no,
so,
but with all due respect, I suspect that we can't speak to it, but I mean, we can't speak with certainty, but I cannot imagine that by next board meeting that we don't have it lifted. Given the numbers and given all the circumstances surrounding a decision like this.
Well, I think we follow Ohio's lead on this, and as opposed to federal lead. We're an Ohio board, and I think we follow the Ohio lead. And so if Ohio lifts it, I think we lift it. I think Dr. Schottenstein brings up a good point about enforcement. And maybe we give, I don't know if it's acceptable to give a 3-month moratorium on enforcement after it's lifted and expect that everything's taken care of by then. So in other words, if it's July 1st, then October 1st to expect everyone to have complied.
Dr. Rothermel.
I would support that. I think that the other thing to consider is that theoretically, even with telemedicine appointments, the patient has the next appointment set. If they're being followed for something that needs routine appointments. So they may need a little more time if they're being scheduled in an office. And the 3 months gives them that flexibility, the office that flexibility, I think, to adjust appointments.
So I would entertain, let's try this through motion so we don't have to let's get a good consensus, if you don't mind. Entertain a motion to Stephanie, how would you like that phrased?
Well, can I ask quickly, Dr. Cacarella, did you have a comment on that? I'm sorry.
I'm just saying that just seems reasonable, that we have a cushion so people can be transitioned safely, and that, you know, whoever, the people aren't unnecessarily being punished or nabbed by us transitioning back.
Agreed. And so before we get to the wording of the motion, the other observation I would like to make is that this would allow us then time, let's say perhaps that the emergency order in Ohio is lifted before our next board meeting. We will come to the next board meeting with a rollout plan of what kind of resuming enforcement, including what communications will do, what the impact is. We'll just have a little bit of a better idea to provide you on what starting back up looks like when we do start back up in that 3-month time period. And I think if we learn more, we could then come back to you too and say, hey, we learned a little bit and the impact of this is going to be really big. And we actually think we might need 4 months or whatever that looks like. So that I appreciate the timeline on that. I think that what we're asking the motion to be for the board is to say that the medical board will resume enforcement of its rules 3 months after the lifting of the state declaration of emergency.
Is
sound okay?
That'd be fine. Is there a motion is there such a motion?
So moved, Dr. Johnson.
Second, Dr. Cacarella.
All right, it's been moved and seconded. Benton, you got, I don't know who did what, but I think it's Dr. Feibel moved and Dr. Cacarella seconded. And that the medical board would resume enforcement 3 months after lifting of the state of emergency in Ohio. It's been moved and seconded. Let's take a vote. Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Reddy.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella.
Yes.
Dr. Feibel.
Yes.
And myself, yes. Thank you very much. Is there anything else that Mr. Smith you want? Oh, Dr. Schottenstein.
Thanks kindly. I was just going to say as per our discussion, since we are doing this independently, which I very much respect that choice, I really think we would be right to communicate with our licensees really in a specific way and help them understand, what we are doing and that it really does not bear on what's going on federally so that, again, to minimize any confusion that they might have. Thanks.
Correct. I agree. And I think it's important that we communicate to them that their obligation to follow our our laws and rules.
Yeah.
Agreed.
Great. Anything else? Otherwise, we will move on to the legislative. Are you all dying now, or shall we press on? Or Dr. Swine, what do you think? We press on?
I'm fine with whatever everyone else
All
wants
right.
to do.
If anybody needs a break, we just go off camera and we'll go forward. All right, Chelsea Wonsky, we're going to talk about legislative update.
Well, good afternoon, Madam President and board members. Thank you for the opportunity to provide an update on legislative matters currently impacting the State Medical Board. Our biggest priorities currently remain the budget and the Interstate Medical Licensure Compact, and we closely monitor various other bills that could have an impact on the board. You probably will regret not taking that break because my update is quite lengthy this month, so I apologize and please bear with me. So as Stephanie noted, the state operating budget was reported out of the Senate Finance Committee yesterday and will now go to the full Senate for a floor vote. Both the House and Senate versions of the budget, as passed, will go to a joint conference committee of both chambers to address the differences between the two versions. Several amendments were added in the Senate Finance Committee version of the bill that impact the board and board licensees, or board licensees, I should say. I will now provide a summary of those amendments. A Department of Health amendment would authorize the establishment of drug overdose death and suicide death review committees at the county or regional level. The composition of members of the committee must include a physician authorized under Chapter 4731. The next amendment is a medical practitioner conscience clause that would allow a medical practitioner, healthcare institution, or healthcare payer to decline to perform, participate in, or pay for any healthcare service that conflicts with moral, ethical, or religious beliefs. The next amendment would change existing provisions to variances from written transfer agreements for ambulatory surgical facilities, including the following. The hospital at which the consulting physician has admitting privileges must be within a 25-mile radius of the ambulatory surgical facility. The consulting physician cannot teach, be employed by, or consult with a medical school, state hospital, or other public institution. The consulting physician must actively practice at a clinic. Actively practice clinical medicine within a 25-mile radius of the ambulatory surgical facility. The next amendment is a provision that was added regarding the One Bite program, which specifies that a practitioner or applicant who discloses that a previous impairment is not subject to discipline for that impairment if the practitioner or applicant has completed treatment and complies with aftercare or remains in good standing with another state's version of the One Bite program. There's an amendment that would permit a physician assistant to personally furnish supplies of specified drugs and therapeutic devices at employer-based clinics. Current law allows PAs to do this in certain locations. The amendment simply expands to employer-based clinics. The next amendment would modify an existing law which allows a physician licensed in another state or territory to provide consultation to a physician licensed in Ohio by eliminating the specification that the Ohio licensed physician who received the consultation from the out-of-state physician must also be responsible for the examination, diagnosis, and treatment of the patient who was subject of the consultation. That sounds confusing. So it basically, the physician that requests the consult or refers the patient for consultation to an out-of-state provider does not have to be the physician who initially provided the examination, diagnosis, or treatment. The next amendment is a provision that exempts from dietetics licensure a person who provides wellness and lifestyle recommendations, individualized nutritional guidance or counseling, individualized food and diet assessment or education, so long as the person does not use the title dietitian or any other title indicating that the person is practicing dietetics. A pharmacy board amendment permits a pharmacist to dispense tobacco cessation drugs without a prescription in accordance with a physician-established protocol that meets specified requirements and establishes record-keeping and notice requirements. It does limit the dispensing authority to nicotine replacement therapy as opposed to all tobacco cessation drugs. It also requires the State Board of Pharmacy to adopt rules in consultation with the State Medical Board and also the Department of Health regarding pharmacists dispensing those tobacco cessation drugs. An amendment for the Department of Mental Health and Addiction Services was added and earmarks earmarks $2 million each fiscal year to be used to support new or expand existing confidential treatment and monitoring programs offered by occupational licensing boards for healthcare workers and with mental health or substance use disorders. And finally, a provision to create a massage therapy advisory council under the state medical board, which was added in the House passed version of the budget, was removed in the Senate version. All of these amendments are subject to change, and it is possible to see the addition of new amendments during the conference committee process. The bill will not be final until both chambers have agreed to the conference report and it is signed by the governor. All provisions that do not rely on an appropriation become effective 90 days after signature from the governor unless otherwise stated in the language. I will note that we received the majority of this information last night, so we are working, I am working with the legal staff to flag and address any concerns. Senate Bill 6, which is the Interstate Medical Licensure Compact. The fourth hearing for this bill is scheduled in Families, Aging, and Human Services Committee tomorrow, and it's up for a possible vote. The language that they are hearing does include those amendments we requested in the Senate to extend the implementation timeline from 6 months to 1 year and also provide appropriations for startup costs. House Bill 122 would permit specified healthcare professionals to provide telehealth services. This bill was passed out of the House and has not yet had a first hearing in the Senate. So we're just waiting for that first hearing there. House Bill 176 has had 2 hearings in the Senate Health Committee. This bill allows athletic trainers to enter into collaboration agreements with a physician or podiatrist and conduct expanded services under that agreement. I would like to thank Dr. Feibel. We reached out to him for his advice on some provisions with this bill, and we are working through those concerns. House Bill 318 makes changes to the existing anesthesiologist assistant statutes. The language does include provisions that would allow an AA to supervise registered nurses, licensed practical nurses, and respiratory care therapists. It also allows for prescribing of drugs or drug therapy related devices in the course of professional practice, and expands upon other services that an AA may provide under a supervision agreement. This bill is awaiting a first hearing, and I'd like to thank Dr. Soin for his help on this one. Senate Bill 151 would establish standards and conditions for the medical care and treatment provided by hospitals and physicians to certain pregnant women and preterm infants and infants born with a disability. The bill would require hospitals to perform aggressive life-saving treatment for viable preterm infants 21 weeks of gestation or later if the hospital has a level 3 or level 4 neonatal intensive care unit. If the hospital does not have a level 3 or level 4 NICU, they must transfer the pregnant woman to a hospital with those services. The bill has had 1 hearing with sponsored testimony in the Senate Health Committee. Senate Bill 157 would create reporting requirements and penalties for an attending physician who fails to report a failed abortion attempt. This bill requires the Department of Health to publish annually the number of failed abortion attempts. This bill has had a second hearing this morning, actually, in the Senate Government Oversight and Reform Committee with proponent testimony. House Bill 196 creates a new license type for surgical assistants to be placed under the purview of the medical board. We have worked with the bill sponsors to request that the language be amended to mirror some of our other license types for consistency and ease of implementation if the language should pass. We are waiting to see those amended changes. Senate Bill 131 and House Bill 203 would require occupational licensing authority to issue a government certification to an applicant who currently holds a licensed government certification or private certification in another state. House Bill 203 has had 2 hearings in the House State and Local Government Committee. Senate Bill 131 is scheduled for a 3rd hearing this afternoon in Senate Workforce, Higher Education Committee. And that concludes the legislative update. I'm happy to answer any questions.
Do we have any questions, Chelsea? Dr. Schottenstein.
Thank you so much. Hi, Chelsea. Chelsea, this surgical assistant licensure bill, this is different than the previous one that was a registry?
Correct. Yes. So this bill would require licensure. You're right. The bill that we saw previously was a registry. And I think, when we talked about it before, the board was preferable to a license because it allows, the board to take action in the event that, there is misconduct or some sort of, something of disciplinary nature.
Okay. Thank you.
Thanks so much, Chelsea. I know that you must have worked long and hard into the night to follow up on that on the budget bill. So we much appreciate your work. If there's no other questions, I guess we would move on to committee business. Is there anything else that we need to talk about with Chelsea? If not, we'll move on to committee business. Is that all right? Okay, the first thing is the appointment of Dietetics Advisory Council and Respiratory Care Advisory Council. May I just make this comment? Jill, thank you so much for your work. This was a bit of a shotgun marriage, if you will, several years ago. These boards didn't necessarily want to become part of the medical board oversight. And thank you for reaching out to affected parties and creating relationships that lets them know that we want to work with them and not just be in a command control position. So turning that, and I know that you've spent many hours in doing that. So thank you so much. And so we'll move on to you filling us in on what you've been doing thus far.
Thank you, Ms. Montgomery. Madam President, members of the board, and the documents you have in your board packet for this month, you will find a memo from me to the president and to Stephanie Luca regarding the selection of members for both the Dietetics Advisory Council and the Respiratory Care Advisory Council. In both situations, we had a time period for people to turn in their applications. We sent out communications to licensees, and I sought the assistance of the appropriate associations who represent the licensees. As far as the Dietetics Advisory Council, there were two positions where the terms had lapsed and were now vacant. And after a consultation with the executive director and the board president, I'm asking that Ashley Pax be considered by the board for reappointment to serve a 3-year term as a licensed dietitian on the Dietetics Advisory Council beginning as of June 9th of 2021. After consultation with the executive director and board president, I'm asking that Stacy Shahan be considered by the board for an appointment to serve a 3-year term as a licensed dietitian on the Dietetics Advisory Council. As far as the Respiratory Care Advisory Council, there are 3 vacant positions, and a memo is in your packet as well on those. Again, we held the application period with a notice posted on our website and sent communications to the licensees and collaborated with the Ohio State Respiratory Care Association. One of the positions that's open on that council is for a physician. And I sent the information on Dr. Richard Gregg to Dr. Coccarella to have him take a look as well.
Yeah, thanks, Jill. I reviewed the CV for Dr. Gregg and information regarding his candidacy, and he's got an incredible breadth and depth of experience in pulmonary critical care, and he's actually done a lot of other advisory roles and even worked in industry, and so he really has a very all-encompassing view of respiratory care and pulmonary medicine. So I think he'd be an outstanding addition to the Respiratory Care Advisory Council. So I would strongly urge that we get him on board.
Thank you, and thank you for your service on the council.
Oh, sure. Thank you.
Also, with consultation with the executive director and the board president, I'm asking not only that Dr. Gregg be appointed, that Matthew Monroe be appointed to serve as a respiratory care professional as of today's date, and as well that Cindy Groeninger be reappointed to a 3-year term to fill the consumer position on the RCAC beginning today. Does anyone have any questions or concerns?
If there are no questions and concerns, we'll just move on to moving to get these people appointed and then move on to Dr. Coccarella for his report. Do I hear a motion to appoint Stacy Shahan to a 3-year term on the Dietary Advisory Council commencing June 9, 2021, to reappoint Ashley Pax to a 3-year term to the Dietitian Advisory Council commencing June 9th, 2021. Is there a motion?
So moved.
All right, so moved by Dr. Schottenstein, seconded by Dr. Johnson. All those in favor? An aye would be by
Aye.
voice. I'm sorry, Dr. Scheibel, do you have a question?
Me?
Okay. All those in favor?
Yes.
Go ahead. You what?
Aye.
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 All those opposed, same sign. They are to be appointed. Do I hear a motion to appoint Dr. Richard Gregg to a 3-year term to fill the physician position on the RCAC with a term beginning on June 9th, 2021, to appoint Matthew Monroe to a 3-year term to fill the RCP position on the RCAP with a term beginning on June 9, 2021, and to reappoint Cindy Greninger to a 3-year term to fill the consumer RCAC with a term beginning June 9th, 2021. Is there a motion?
So moved, Dr. Cockrell.
Dr. Coccarella moves. Is there a second?
Second.
Second, Dr. Johnson.
Dr. Safran moves. It's been moved and it's been seconded by Dr. Safran. All in favor, voice vote.
Aye.
Aye.
Opposed, same sign. The ayes have it, and they are appointed. We will move on to the Respiratory Care Advisory Council. Dr. Coccarella, thank you so much for your service on this council. It's all yours. The stage is yours.
Okay, thanks. The Respiratory Care Advisory Council was held yesterday on June 8th. The minutes from the December 2020 meeting were reviewed and approved by the council. A brief legislative update was given. A presentation was given by Nelson Hayes, the clinical director for the Ohio Physicians Healthcare Program, regarding their organization and all the services that they offer to get assistance to impaired licensees. Brandy Dorsey, the chief of compliance for the medical board, was introduced to the RCAC members yesterday, and she gave an explanation regarding her duties. And Sue Chiarillo from the Ohio Society of Respiratory Care spoke about the trends she sees regarding respiratory care professionals in Ohio renewing their licenses. There probably was a pandemic-related phenomenon in that anecdotally, I've seen it as well. Several members that are RCAC saw that people that were probably less than 2 years away from retiring did not renew licenses because they thought, with everything happening in the last year or so of their entire career, and most of them being on the older side, they didn't want to probably soldier through the pandemic in the ICU and with all the high-risk patients. So we'll keep monitoring that situation as we kind of now are lifting ourselves out of the pandemic and see what the trends are with respiratory care professional licenses moving forward. And we'll obviously be reporting back what those trends look like. And that was essentially it. The next meeting of the Respiratory Care Advisory Council will be held on September 7th, just prior to the September full board meeting, and I'll be reporting back any findings by then.
Thank you very much, Dr. Coccarella. Moving on then to Dr. Schottenstein, would you mind giving us a report on the Medical Marijuana Expert Review Committee?
Sure, of course. Thank you, Ms. Montgomery. So the Medical Marijuana Committee last met on May 12th after the monthly board meeting. For the first item of business, I ask the board members review the minutes from that meeting. Is there a motion to approve the May 12th, 2021 Medical Marijuana Committee minutes as drafted? Motion, please.
So moved. Soin.
Thank you kindly. Is there a second?
Yeah, I second.
Dr. Reddy, thank you. Voice vote, all in favor, aye?
Aye.
Aye.
All opposed? Thank you. Next, I would like to report out the recommendations made by the committee regarding petitions for new qualifying conditions. From November 1st through December 31st, 2020, the Medical Board received 30 petitions for potential new qualifying conditions. Petitions for 6 qualifying conditions were moved forward for further review and discussion. They are autism spectrum disorder, restless leg syndrome, Huntington's disease, panic disorder with agoraphobia, terminal illness, and spasticity and spasms. The committee wished to have additional input on restless leg syndrome, Huntington's disease, terminal illness, and spasticity and spasms, as these conditions had not previously been discussed by the committee. Dr. Robert Albright, who is board certified in both neurology and in hospice and palliative medicine, submitted written reports which all board members have had an opportunity to review. The other 2 conditions, autism spectrum disorder and panic disorder with agoraphobia, had come before the board previously, but there was new scientific information submitted this year. The committee reviewed the new information, but did not feel there was compelling evidence that medical marijuana could provide better outcomes with less consequence than current medical treatments. Is there further discussion from the board? Okay, hearing none. The board can vote on the committee's recommendations. The committee decided, based on Dr. Albright's recommendations, to separate the petition for spasticity and spasms into 2 topics. The committee recommended approval of the petitions for Huntington's disease, terminal illness, and spasticity. Do I hear a motion to approve the petitions to add Huntington's disease, terminal illness, and spasticity to the list of qualifying conditions for treatment with medical marijuana? Motion, please.
So moved.
Dr. Kakarala and Dr. Reddy, thank you. Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Dr. Sohn?
Yes.
Myself, Michael Schottenstein, yes. Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarala?
Yes.
Dr. Feibel?
Yes.
Ms. Montgomery?
Yes.
Thank you so much. The committee recommended rejecting the petitions for autism spectrum disorder, restless leg syndrome, panic disorder with agoraphobia, and spasms. Do I hear a motion to reject the petitions to add autism spectrum disorder, restless leg syndrome, panic disorder with agoraphobia, and spasms to the list of qualifying conditions for treatment with medical marijuana? Motion, please.
So moved. Dr.
Dr.
Pepper.
Johnson, Dr. Kakarella, thank you so much. Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Dr. Sohn?
Yes.
Myself, Michael Schottenstein, yes. Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarella?
Yes.
Dr. Feibel?
Yes.
Ms. Montgomery?
Yes.
Thank you all. Please note that the board will again accept petitions for new qualifying conditions from November 1st through December 31st of this year. Previously rejected conditions may be considered again as long as the petition includes new scientific information. The board will also vote in the fall to set the petition window for 2022. Thank you. That concludes my report.
Thank you very much. We'll move on to the FSMB Recommendations Review Committee. Dr. Schottenstein, you're on board again.
Okay, thank you so much. So the FSMB Review Committee did meet this morning. The agenda was to discuss the proposed Salesforce form for the Nascent Quality Assurance Committee. It is a template that will be utilized by the reviewer to provide a roadmap of the case. It is essentially divided into 4 categories: complaint intake, complaint process, complaint disposition, and committee member assessment. Board staff actually has some experience with case review based on our utilization of expert reviewers regarding the historical case review of sexual misconduct that we recently completed as part of the governor's working group recommendations. The information will be presented to committee members in PDF form so that it is word searchable. We can anticipate a memo going out to all board members next month, laying out the process and asking for volunteers for the committee. We are anticipating a committee of 4 physician members and 1 consumer member, which would meet quarterly. We are contemplating 2 case reviews per committee member per month. We contemplate sexual misconduct cases being turned over to the consumer member of the committee, while minimal standards reviews will be turned over to the physician members. The reviews will be performed by Quality Assurance Committee members using Salesforce, and the staff is working on training materials, as we heard Stephanie say earlier, such as videos to help us learn that program. And there will be a dedicated staff member assigned to this process. We may recall that another recommendation of the FSMB was to include a consumer member in the complaint review process at the secretary and supervising member level to review sexual misconduct cases, but we need a statutory change to implement that recommendation. On that note, we have had substantial stakeholder feedback regarding our proposed legislation, and we hope that it will be considered by the legislature after the budget wraps up. The Office of Budget and Management is finishing up their review of our sexual misconduct protocol. That should wrap up around the end of the fiscal year. Is there any discussion? Thank you so much. That concludes my report.
Thank you very much, Dr. Schottenstein. Dr. Soin, you're on deck.
Yes, hi. So I'm going to do the ICD-10 committee update. We met earlier today, and basically we're working on a website and tool for us to use to track and allow physicians to track the ICD-10 code placed on prescriptions. And what we really need as far as next steps, we're going to be talking to the Board of Pharmacy just to make sure that there's data integrity on any tool that we have. And one thing that was clear in our meeting earlier today is that we want to make sure that anything that we launch has strong or rigid quality controls to make sure that the data is accurate. Because if there's not a lot of data accuracy or concerns about data accuracy, it will make it very difficult to adopt it as a viable tool in the future. So basically, that's an ongoing process. We're going to just see how it goes and make sure that whatever tool we release is one of as high quality as we can practically get it. And so I will update you after we get more information on that regard. And that concludes my report.
Thank you very much, Dr. Soin. I appreciate that. We move on again to Dr. Schottenstein for the Finance Committee.
Thank you so much. So looking at our fiscal update for April 2021, revenue was $1,387,486. This is a substantial increase from the previous month and represents some catching up from the renewals that had been delayed with regard to the July 1st deadline extension, which we have previously discussed. As a preview of the main numbers, we have over $1 million in revenue, and our cash balance will go back up over $6 million. You may note that our April cash balance has increased to $5,895,665. Payroll and spending are essentially unremarkable. We received $7,180 in disciplinary fines in April. Any discussion of fiscal matters so far? We have 4 orders of new business. And they'll look substantially familiar because, we're starting up with the new fiscal year and we just sort of have these, perennial ad hoc motions for additional funding. The first is with regard to the nurse reviewer contract. The standards review unit currently consists of 2 nurse reviewer positions, one of which became vacant this year. The unit supervisor, Brandy Dorsey, continues to assess the volume and type of work done by these staff prior to making a determination regarding permanent backfilling of that vacancy to see if any restructuring of the duties would be more efficient. As a temporary measure, in order to avoid a backlog of case reviews in the unit, the board had entered into a contract with Jack Holdford, an RN formerly employed with the board as a case reviewer during fiscal year 21. This contract has been very beneficial in addressing a potential backlog. Mr. Holdford has completed the review of 37 cases as of May 27th, averaging 5 cases per week. We are seeking approval to renew this contract during fiscal year 22 in an amount not to exceed $24,000 for the continuation of this effort. The hourly rate for this review work is $29.16, which is equal to the starting base pay of a nurse reviewer. The terms require 15 to 30 hours per week, extending through the fiscal year or until the maximum is reached. Earlier today, the Finance Committee passed a motion to this effect. There's a motion, please, to enter into a contract with Mr. Holdford for fiscal year 22 in an amount not to exceed $24,000. Motion, please.
So moved.
Dr. Safran, thank you. Is there a second?
Ended.
Dr. Reddy, thank you kindly. Is there discussion? Okay. Voice vote. All in favor? Aye.
Aye.
All opposed? Thank you. Second order of new business is with regard to special counsel assignment. Beginning in December 2019, Schumacher, Lupin, Kendrick was appointed as special counsel to defend the State Medical Board of Ohio in responding to subpoenas ducis tecum and subpoenas for deposition issued in opioid-related lawsuits. including the multi-district litigation in federal court in the Northern District of Ohio and litigation filed against pharmaceutical manufacturers and distributors in Ross and Madison counties. The opioid litigation is ongoing. As Ms. Luca mentioned in her operations report at the May board meeting, the projected cost of this continuing litigation is estimated at $75,000 for fiscal year 22. Any controlling board request needed to cover this contract will be handled by the Attorney General's office. Earlier today, the Finance Committee passed a motion to this effect. Requested motion is to please authorize the payment of up to $75,000 during fiscal year 22 for the law firm of Schumacher, Lupin, Kendrick to perform special counsel services on behalf of the board in the opioid litigation. Motion, please. Dr. Carolla, Dr. Reddy, thank you so much. Is there discussion? Okay, voice vote. All in favor, please. Aye.
Aye.
All opposed? Thank you. Our third order of new business is with regard to hearing attorney examiner services. The medical board currently employs 2 full-time hearing examiners and has been utilizing the services of Rhonda Szymanski, a private attorney, for contract hearing examiner services, as Ms. Szymanski has years of familiarity with the board's hearing processes and has the experience necessary to take on large, complex cases. Approval of this request will allow the hearing unit to continue to shift a number of cases to Ms. Szymanski during fiscal year 22 as the need arises. The contract will not exceed $48,925. Earlier today, the Finance Committee passed a motion to this effect. May I please have a motion to enter into a contract with Rhonda Szymanski for fiscal year 22, not to exceed $48,925 to perform hearing attorney examiner services. Motion, please. Dr. Safran, Dr. Cacarella, thank you. Is there discussion? Okay, voice vote. All in favor, aye.
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 All opposed? Thanks very much. Our last order of new business is with regard to the purchase of additional Salesforce development hours. As we have done in previous years, we are seeking approval for dedicated IT support from the Department of Administrative Services, DAS, to prioritize the board's enhancement projects in Salesforce and eLicense. During fiscal year 21, we pursued and deployed 13 system enhancements totaling $32,500.60. Several of these enhancements refined application questions and background sections to improve the application process and streamline the back office review of a more completed application upon submission. Legislative changes were also included to comply with House Bill 442. Finally, several enhancements improved and automated back office processing and monitoring functions such as name change requests, complaint record activity data, and subpoena authorization workflows. We anticipate the need for further system enhancements in fiscal year 22, many of which likely will not be known until the fiscal year has commenced. Those currently slated for development in the coming year are license verification request automation and an entire system build-out to handle the expert process from start to finish. The rate per hour for fiscal year 22 is $118.40. The staff is requesting that the board approve up to $35,000 for fiscal year 22 with an estimated 300 hours of development. Earlier today, the Finance Committee passed a motion to this effect. May I please have a motion to approve the authorization of up to $35,000 for dedicated Salesforce development hours from DASOIT? Motion, please.
So
Dr.
moved.
Safran, Dr. Carolla, thank you kindly. Is there discussion? Voice vote. All in favor, aye.
Aye.
All opposed? Thanks kindly, everybody. Any other fiscal matters for discussion today? Okay, that concludes my report. Thanks so much.
Thanks so much, Michael. You've been a yeoman in so many of these committees. Appreciated it.
Very kind. Thank you.
We're going to move on now to the Licensure Committee. Dr. Safran will address the Licensure Committee business to the board.
Thank you, Madam President. Today for board consideration, we have 6 licensure requests. Information on each of the requests have been prepared by licensure staff and distributed to board members. Does any board member wish to consider any of these applications separately? Seeing none, do I hear a motion to approve the licensure staff recommendations for the requests of Sarah McCatherine, Navdeep Singh, MD, Laura Anzo, Leah Navzinger, MD, PhD, Jacob Kaufman, MD, PhD, and Aaron Wortman, MT. Do I hear a motion?
So moved.
Dr. Cacarella, Dr. Reddy, is there any discussion? Dr. Rothermel?
Yes.
Myself, Dr. Safran, yes. Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. This concludes the Licensure Committee report. Thank you.
Well, thank you so much. Appreciate that. We're now going to turn to the probationary reports and requests, and that would be turned to the compliance section. And we have a reinstatement request. Do I hear a motion to approve the request for the reinstatement of the license of John Zano, Doctor, MD, effective immediately, subject to probationary terms and conditions as outlined in November 13th, 2019 board order for the minimum of 2 years? Is there a motion?
So moved.
Dr. Johnson.
Great. Thank you so much. It's been moved to Dr. Coccarella and seconded by Dr. Johnson. Is there any discussion on the motion? If not, we'll move on to a voice vote on that, or a roll call. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Dr. Feibel?
Abstain.
And Betty Montgomery? Yes. So we'll move then to a conference or office conference review. Do I hear a motion to approve the compliance staff's reports and conferences for May 10, 11, 2021?
So moved.
Motion been moved by Dr. Johnson, second by Dr. Coccarella. All in favor, voice vote? Aye.
Aye.
Opposed, same sign. It passes. We're going to go to the probationary requests. At this time, we will consider probationary requests in today's agenda that have been prepared by the Standards Review and Compliance staff and distributed to the board members. Before asking for a motion, does any board member wish to consider a probationary request separately? If not, do I hear a motion to approve the secretary and supervising members' recommendations for probationary requests? We have a motion?
So moved, Dr. Coccarella.
Moved by Dr. Coccarella and seconded by Dr. Johnson. A roll call, Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Dr. Feibel?
Yes.
And myself, yes. I know this comes as the motion passes. I know this comes as a sad moment, but it's now 1:33, and I think it concludes our June 9th meeting for the State Medical Board of Ohio. Do I hear a motion to adjourn?
So moved.
Forever. Dr. Safran, you'll do the duty, and there's a second by whomever, Dr. Johnson. All in favor? Aye.
Aye.
God bless you all. And all opposed? Nobody's opposed. I can't imagine that. Thank you for your hard work. We did a lot of work today, and
This conference is no longer being recorded.
It'll be so nice to see you all in person. Thank you so much. See you soon. Take care. God bless.
Good job, Betty.
Good to see everybody.
Thank you.
Have a nice
Bye-bye.
month.